Hi everyone, welcome to the Asset Protection 2012 update. Introducing Douglas Lodmell, tonight's presenter and the founder and managing partner of Lodmell & Lodmell. Doug?
Thank you, Wayne, and thank you all for joining us on this webinar. This is our 2012 Asset Protection Update webinar, and I really want to welcome everybody who's on the call. There's a lot of clients on this call. We actually had over 700 people sign up for this webinar, so clearly there was a huge demand for this information. Everything that we told you about in the invitation, we're going to cover point by point. So if there was something specific that you wanted to see, we're going to get to it. So the clients that are on the call, I welcome you. I really appreciate you. And this is a great refresher. We're going to talk about how to use the plan that you have in place. And there's certainly going to be questions that will come up from you. If after this webinar there are questions, please, you know what to do. You call Coletta and schedule an appointment, and I'm happy to speak with you absolutely anytime. For the people on the call who are not clients but who are interested in asset protection, this will be a great webinar because you'll be able to hear what clients need to know about using their plan, as well as going over the plan itself and the tools that we use to protect assets. And finally, there are on the call, when we looked at the list of over 700 people, there were quite a few advisors. That means attorneys, CPAs, and financial advisors. And you are welcome. We work with a lot of advisors. In fact, of course, virtually every client has an advisor. We work with all of those advisors, and we also work directly with advisors who understand the need for asset protection, who are wanting to add that as a component to their plan that they provide to their clients, and who are not experts. So we will give you information on how to contact us if you do want to work with us directly with your clients. So let's get started. Asset Protection 2012, Lodmell & Lodmell Update. So Asset Protection 2012, let's talk about the bullet points that we brought up. Using your existing plan effectively. So this is really focused on the clients that have a plan, as well as anyone who ever has a plan. It's pretty critical that you use it properly. The other thing, before we get too far, if there are questions, there's a lot of people on this call, and I already see questions popping up. So feel free to put them in the question box. They won't be lost in there. I won't necessarily be able to get to each one as they come up, but we are going to spend time on questions at the end of this webinar. If I do see a question that is if I can catch it while I'm watching, that's relevant to what we're talking about, I'll stop and answer it. But definitely write your questions in the box, and we'll get to as many as we can. If we don't get to your question on this call, you can expect an email with a direct response from us. We will answer absolutely every question that's typed in there. So please type in your question if you have one. So using your existing plan effectively. Let's talk about fundamentals of your planning, which includes where and how assets need to be owned, and critical mistakes to avoid. This is obviously really important. Having a plan and making one wrong mistake and having it not effective is really no fun for anyone. And for those who are on the call who are not yet clients, getting new asset protection if you don't already have it. We're going to talk about that. And we are going to talk about some asset protection strategies that you already have. You probably don't know you have, but that are already working for you. Okay, fundamentals of your plan. Let's start off with a principle. And the principle is you do not need to own an asset to have beneficial use and control. So this is a pretty straightforward concept. We can all relate to a neighbor who has a very nice boat who says, hey, go and use it anytime you want. And that means you can use it, you can enjoy it, but you don't own it. So if something happens to that boat, well, that's not really your problem. It's also not yours to lose. So if you get sued and someone says, hey, I see you out on the boat every weekend, I think we're going to want to grab that. You can say, well, it's not my boat, it's my neighbor's boat. This concept is a very old legal concept. The idea that you don't have to own something to use it. It's been used by families, by individuals, and by companies since the inception of the legal system. And one tool in particular that we're going to talk about in detail is called a trust. And a trust is precisely that. It's the distinction between ownership and beneficial use and control. And it really is one of the most powerful concepts in the law, and it's a really key part of what asset protection is. So is it possible to create a separation of ownership from beneficial use and control of your personal assets? Well, we know for your neighbor, that's easy. That's not your boat. You're just using it. But what if it is your boat? What if your boat is floating out in the back of your yard and you're using it? Is there a way that you can separate ownership of that boat from beneficial use and control of it? Well, the answer is yes. And this really is the world of asset protection. This is really what we're talking about when we talk about asset protection, is precisely this. So how do we do it? Do it with 3 tools. And I've put these little pictures up here mainly to remind you of what they represent in the short 6-minute video that I hope you all got a chance to see. They are the limited liability company. That's our briefcase in the video. The asset management limited partnership. That's the safe in the video, and that safe is where the briefcases go, as well as all the cash and liquid assets and investments and stocks and bonds, etc. And then finally, there's the International Wealth Management Trust. In our video, that's the boat. That's what we put the safe on if it looks like the sharks are circling and we sail it off to a safer place. So if you have these plans in place, then the key is to fund the plan. So important to know, your assets are not safe until your plan is funded. So if you've got a limited partnership or a limited liability company and you put it in place and you registered it with the state and you're all legal, but you never put anything in it, it's not funded. And if it's not funded, it's not working. You have to put things in the safe in order for the safe to be useful. Same concept as if you have a safe in your house. It'd be great, you have this really fantastic safe that no one can get into, but you forget to put the assets inside the safe. So critical that you actually put them inside the safe and fund the plan properly. When we fund in an asset protection plan, we make a distinction between risky assets and safe assets. So you see in the safe picture there, we have safe assets at the top, and that's your cash, that's your stocks and bonds, your jewelry, anything that in and of itself can't hurt anybody or create its own liability. So you can't really hurt anybody with a $100 bill or a stack of $100 bills. They don't have a risk component. But you can hurt somebody with a motorcycle, with a house, with a car, with a boat, with an airplane. Anything that has a motor, a door, a key, anything you can start, anything you can walk on, anything you can fall down on, those are all risky. And inside the risky asset arena is also businesses. You can hurt somebody with your business via the product you sell or the service that you provide. So businesses themselves are seen as risky assets. So when we create a plan, or when anybody creates a good asset protection plan, they're going to make a distinction between what is a safe asset and what is a risky asset. And they're going to make sure they don't mix them up. So the last thing we want to do is create an LLC and then put your rental real estate property in there and put a bunch of cash in there too. Because if something happens on the real estate and it gets sued, then you've exposed the cash. So by making this distinction and using these tools in conjunction, we're able to separate. And then ultimately we do combine them once they're protected. So we see the briefcases inside of the safe, those all contain those risky assets, and the safe assets are directly in there. So we're talking about what are safe and risky assets. Well, those things, cars, boats, houses, anything that can hurt you. And they should be held in compartments. So if you do have a car, or better yet, a car collection, or an airplane particularly, and probably the most common for you listening on the call is a piece of real estate. A piece of real estate is the most common risky asset that we're going to use a separate entity for, and that entity is going to be the limited liability company. So if you're listening and you're a client and you have the plan, the thing to take away from this is to make sure that your assets are properly funded, that your real estate is in the plan, you haven't taken it out, you haven't bought new assets and not put them in the plan. So it's just important that you manage that and you're aware. What about bank and brokerage accounts? These are safe. Are they for your limited partnership? Are they for your asset protection trust? And what should you do with personal income? Okay, bank and brokerage accounts are safe. So they're for your limited partnership. You can put them directly in because, as we said, they're not going to create risk. So your statement should say the ABC Limited Partnership on your savings brokerage account. Your asset protection trust is going to own the majority interest in that limited partnership. And that's what provides that ultimate protection. Now, I get this question a lot. What should you do with personal income from your job, business, or your practice? Well, the answer is that if it stays in your job, business, or practice, so if you own your practice and you continue to fill up the coffers with retained earnings and you're not making distributions and you're just letting cash build up in your practice, not a very good plan. That's not safe. Cash inside of your practice is subject to the liabilities of the practice. Well, if you're a doctor, your practice is one of your riskiest assets. That's what we're protecting against. So to have a bunch of cash in there is to defeat the purpose. What about real estate? What about your office building? Your office building also should not be in there. That's a valuable asset, particularly if it has equity or if it's completely paid for. So we would want that first in your limited liability company. And again, if you're a client, that's the way we've set it up for you. And it's just important that you understand that distinction of how to manage that. Your practice will pay rent to your limited liability company, so it's still a deductible expense, and the limited liability company will pay the mortgage if there is one, and pay the expenses depending on what kind of lease you sign between yourself in the form of your practice and your limited liability company. But the protection is the key there. Okay, what about primary residence? This is a biggie because this is often one of our your biggest assets is your primary residence. So there's some good stuff here. One, consider the homestead laws. If you live in a certain state, your house is protected. So for example, if you happen to live in Florida, congratulations, your house is completely protected. If you happen to live in Texas, congratulations to you, your house is protected. If you happen to live in California, my condolences, your house is very weakly protected. $50,000, $75,000 if you're married. It's a weak form of protection. Most states are more like California and not like Texas and Florida. So it is important to understand where you should hold your home. So it's either going to go in your individual name, your asset protection trust, or your family limited partnership. So this is a question. The answer is it's going to go either in your individual name, but most likely in your asset protection trust. And again, we're going to talk a little bit about the trust, but your trust is where you want your primary residence. The reason for that is that it gives you all the benefits of primary residence ownership, the tax benefits, the tax-free capital gain, the home interest mortgage deduction. It maintains all of those, but it also protects the home. So if you're not in a great homestead state, that's the place that you want it. Family limited partnership, you would not want it in there. Why? Because it's a piece of real estate and it's a risky asset, so we wouldn't put it directly in there. And individual name, would you want it in your individual name? There are a few circumstances where we will do that. And that would depend on the state that you're in, the amount of equity that you have, or in some cases, the home is actually looking like it's going to be more of a liability than an asset in the form of the equity has disappeared as the value of the property has gone down. We may want it in your individual name if there's a chance that you will be defaulting on the mortgage in the form of a strategic default. And we're not going to go into strategic default in detail on this webinar, but I do have an excellent paper that I've written on strategic default. If anyone listening to this call is in the situation where they have equity that's gone and now the loan or mortgage on the property exceeds the value of the property, they really should be considering significantly what they need to do with that particular asset. And I invite you to call me around that one because that's one that really needs to be walked through specifically with your situation. But even if you have assets and you can pay your mortgage, there are reasons for you to consider at least the option that you should walk away. So call me if that's your case. Or go to lodmel.com, and right below the video there is a link to strategic default considerations. So I would recommend that you read that. Okay, how about second homes and non-rental property? Second homes and non-rental property are, as we know, risky assets. So they're real estate. You can hurt yourself on them. So they're either going to go into the asset protection trust, or they're going to go into a limited liability company. And it's going to depend on the character of the property, the equity of the property, how you use the property, and even where it's located. Investment or rental real estate. Well, you know, if you have a plan, that is almost certainly in a limited liability company. So that's back to the briefcase we talked about. That's where it needs to be, because it's going to wrap up and limit the liability. And it's very good because it works both directions. When you put your property in a limited liability company, and then that limited liability company is in turn owned by your limited partnership, which in turn is owned by your asset protection trust, you're protecting the equity of that property from lawsuits. And I call these outside lawsuits or external threats. So if you get sued from a car accident or employee or malpractice or anything outside of the property itself, then having the property in the LLC properly connected to your plan is going to provide protection for that equity. It also protects from inside liability. In other words, it protects the rest of your assets from the property itself creating a liability. So if the property, somebody has an accident, a slip and fall, there's a death on the property, and the owner is being sued, well, the owner is you in the form of the limited liability company, not you in the form as you personally. So it limits that liability. And that's literally what it means when it says limited liability company. The owners of the company are not responsible for the liabilities of the company. And so it's a very good tool to protect from both directions of liability. What else does an LLC do the exact same thing for? Boats, planes, other risky assets. So again, if you're a client and you're listening to this and you're putting your own plan together, think about those assets, think about where they are, and make sure that they are exactly in those places that they're supposed to be. So if you have a boat, now let me say a couple things on risky assets that are very small. So let's say you have a John boat or a rowboat, just a really teeny little thing. It doesn't, it's not worth $1,500. So you're not really worried about protecting the boat. What you're worried about is protecting yourself from the boat. In that sense, insurance is probably your best bet, and you probably don't need to create a separate limited liability company to own one small boat or one jet ski. Then again, I do have clients that have an LLC, and some of them even call it, ABC Toys. And it holds not one little boat, it holds 3 jet skis, 2 snowmobiles, a hang glider, a parasail, and 3 motorhomes. Okay, that's different. If you have a lot of toys and a lot of risky toys, then we probably do want to create an LLC for those separately. Okay, these are big ones. Retirement accounts. Retirement accounts are your qualified retirement accounts. I'm not referring to retirement money that you've set aside or insurance, blended plan that you're going to ultimately use for retirement. I'm talking about retirement plans that are qualified. That means ERISA plans, 401k, 403b, pensions, defined benefit, defined contribution plans, and non-ERISA plans like IRAs. What do you do with these things? Well, the answer is they're already protected for the most part. And you can't do anything with them. If we try to take your 401k and do something with it, we trigger the tax consequences of it. So the good news is that they're already protected, particularly ERISA plans, the ones in the middle there. They have very strong statutory protection. Non-ERISA plans like IRAs are protected depending on the state. And there's case law now that's starting to address whether or not they're going to have the same protections as ERISA plans. The answer on that is if you have a significant amount of money in an IRA, you should call us and we can discuss your state, your specific situation. There is a way to additionally protect non-ERISA plans, IRA accounts, without taking the money out. and it is a very effective way, but it really only makes sense to do if there's a significant amount of money in there and you're in a state which you don't already have good protections. Okay, let's move on to the Asset Protection Trust. This is really the key to the whole plan. The domestic part of it is very good. We have strong statutory protection in the form of a charging order from the state of Arizona, where most of our limited partnerships are set up. It provides a first layer of defense, but ultimately there's a problem, and that's principle number 2. Possession is 9/10 of the law. I just can't tell you how true this is. And when it comes to the legal system, possession is 9/10 of the law. It really is. So you want to make sure that you use this to your advantage and you're not having it used against you. So the bottom line is that courts exercise jurisdiction over everything within their boundaries. So a U.S. court has jurisdiction over everything. So we can have a great domestic plan with 4 limited liability companies, a rock-solid asset management limited partnership, done properly and aged well. And we could still have a U.S. court decide that they're going to pierce the plan. Why? Because they have the power to do so. And if you at some point end up an unsympathetic defendant, for whatever reason, you cannot be 100% sure that your assets will be protected in a purely domestic plan. That's where the Asset Protection Trust comes in. The Asset Protection Trust is an international trust, and therefore it allows you to do just what we said, specifically separate ownership from beneficial use and control. And more importantly, it enables you to move the assets beyond the reach of the U.S. courts. And this is the critical piece. It literally allows you to move the assets out of the U.S., away from the U.S. judge, away from the U.S. juries, and away from that. Possession is 9/10 of the law. You have possession, and so puts you in the driver's seat. And that's what asset protection is all about. In the last 4 years, lawsuits have increased dramatically. I see it in my office. We have triggered and needed to use more plans in the last 4 years than in the previous 14 years combined. The reason for that is that the economy created a lot less money. And when there's less money out there, there's more people fighting for that less money. And that means more conflict. So more partnership disputes, more lawsuits in general designed to simply move assets from the person suing from the person being sued to the person suing. And the legal system there's more advertising for plaintiffs' attorneys. So it really is more important than ever that you maintain your plan, that it's updated properly, and that you have one in place. So the Asset Protection Trust, what goes in your Asset Protection Trust? Well, the first thing is the majority interest in your limited partnership. So that safe, that safe that holds all those limited liability companies and all those other assets like stocks and bonds and cash directly, itself is owned by the Asset Protection Trust. That's the connection that allows us to ultimately move the money. And in states without good homestead protection, it's going to be your primary residence. And here's the key. You control the whole thing, and it's passed through taxation. So we don't have a taxation issue where we're creating a negative feedback loop of taxation where you've given your assets away and now you have to figure out who pays the taxes on them. It's the way that the plan is structured and the way that all good asset protection plans are structured is tax neutral. Meaning we're not going to create completed gifts for the most part unless we very intentionally do it. And we're going to create a tax neutral plan where your tax picture looks the same after your plan than it did before your plan. So how can you mess this up? Critical mistakes that you want to avoid. 1, signing for your limited partnership. Your limited partnership should never, ever conduct business or guarantee loans. Unless, of course, you're using that particular entity to conduct a certain business. So that's the exception. But if you're using it to hold assets, it shouldn't be conducting another business. So you shouldn't be creating more risk. And most important, you should not be using it to guarantee loans. That's what I've seen get a few clients in trouble these last few years, is that they actually signed on behalf of their asset protection plan or their limited partnership on a loan that they did. Now the reasons are understandable. The bank required it, or they didn't realize that they could say no. They didn't think there was any chance that they weren't going to repay the loan, and then we saw what happened. But a personal guarantee should remain personal. It's a personal guarantee. It should remain a personal guarantee. The key with it is that to do that, you need to make sure that you don't inadvertently obligate your asset protection structure to a guarantee. What other critical mistakes can we avoid? Well, not respecting the corporate formalities. This means things like failing to set up segregated accounts for your limited liability companies or your limited partnerships, using a limited partnership or an LLC to pay personal expenses, these types of things. The reality is that both limited partnerships and LLCs are extremely easy to maintain. They don't require minutes like a corporation does. The states that we use for the most part don't require annual filings, so it's very hard to miss a filing and have your plan inadvertently dissolved. But nevertheless, it's something that you want to have good practices around keeping things separate. So if you have a rental property in an LLC, that LLC should have a bank account. Rents should be deposited into that bank account, and that's bank account should be used to pay the expenses related to it. You shouldn't go shopping at Costco with your LLC bank account or your limited partnership card just because that's where the money is. You are always free to take money from your plan. You control your plan. But the way you need to take money is to take it out, put it into your personal account, and then spend it from there. Don't spend it out of the business unless it's a business expense, in which case you should definitely spend it out of the business, and you should deduct it if it's a business expense. We don't want your plan conducting business, but the exception to that is that it is going to conduct one business, and that is the business of managing your assets. That's the business it is allowed to be in. It doesn't create liability, and that business is allowed to have its own expenses and its own accounting. So important to keep those things in mind as you're setting up your property. What else can we do? Well, we don't want to deed property improperly. I've seen this come up with sometimes there's tax issues, which means that if you deed a property into an LLC, for example, it could trigger a reassessment, or it could change your capital gains exemptions. So how do we handle that? Well, there's some best practices to fund your plan properly at the get-go. Pretty easy to do. For example, California is a big state that likes to reassess your property every time you switch the ownership, but there's an exemption for that. And the exemption is that if the ownership is switched into an entity with the same owners as the original owner, then it's exempt from a reassessment. So what does that look like? Well, the property goes into the LLC with the exact same ownership. So if the property is owned by one person, well, the LLC should be owned by that same person. The property is transferred in, and then the LLC can be moved into the limited partnership. If you do it the other way around, you're going to trigger a reassessment. And each state has some uniqueness around it, and these things are specific, and we walk our clients through each of those states when we're doing a plan for them. Another thought for clients: protection without an asset protection trust. This is really what can the Family Limited Partnership achieve on its own. The Family Limited Partnership is a great tool, especially the way we draft it. Ours is called an asset management limited partnership. It's specifically designed for asset protection. It's very good. The limitations of it are really what we said earlier about the limitations of any domestic plan. The judge has jurisdiction. So possession is in the form of the judge. So we know possession is 9/10 of the law here. So possession is here in the United States because that's where the jurisdiction is. So it is very good. And depending on what it's holding and what we're protecting, it may be enough. But I can tell you that if your assets are in excess of 500,000 that are inside of the limited partnership, then it really doesn't make me feel comfortable just having the limited partnership. You know, occasionally I'll run into a client that, or someone that calls and says, yes, I've done asset protection, I have a plan in place, I have limited partnerships set up by another law firm, and I look at the plan and I talk to the client, and it turns out he's got $2 million of cash sitting in limited partnerships, and it's just not enough. That is way, way outside of the range that I would feel comfortable, because that's a lot of money. And I say that not from a standpoint of subjective, I'm talking about objectively. In the mind of a plaintiff's attorney, that's enough money for them to put a lot of effort into breaking through that limited partnership. So what we find is that when it gets over $500,000 of protectable assets inside the limited partnership, you really should be looking at adding the asset protection trust. What do you gain? Well, you gain the true solution to the problem, because we can then physically move the assets outside the U.S. jurisdiction. And again, key to the whole plan is being able to keep possession. You can do this legally, you can do it ethically, but it has to be done properly, and it has to be set up in advance of having a big knockdown problem. It's hard to add the fire insurance when the house catches on fire. In fact, I live in Florida, and you can't add hurricane or flood insurance during the hurricane season without a waiting period. So you can't wait till you know, Hurricane Wilma is 500 miles away and they're projecting a possibility in 2 to 4 days, call up and say, hey, it hasn't hit yet, let me get the insurance. They say no. Same thing here. You really need to have your planning in place as long as possible. Waiting is always working against you. Time is working against you when it comes to asset protection. The sooner the better, the older the stronger. Okay. Now we're going to move into really for people who haven't gotten asset protection. Who needs it? Who needs asset protection? You know, the answer is really anyone with equity in their assets. And I mean anyone. You know, clearly high-risk professionals need it because they already are running risks that are greater than the average. They're already targets. And business owners, especially if you have employees. And let me say a little bit about employees. This has become the hottest topic in the last 5 years for plaintiffs' attorneys. I have a friend who runs a company in LA. California is a very difficult state to have employees. It's very, they make it very unfriendly to employers. And he has about 200 employees. And one employee filed an employee-related lawsuit. It was won by the employer. Nothing was done wrong, but the attorney that had the lawsuit literally started fishing inside of the business. Was just saying, hey, ask your friends, tell your friends, and he had this attorney sitting outside of his business just waiting for his employees to do something or become available to him to grab his clients. So, you know, all these things demand that you have protections in place. And it's not just the doctors anymore. It's not just the people with the super high risk professions. It's anybody with assets that you want to hold on to. We're in a super litigious society. It's only gotten worse. And having asset protection, and if the last 4 years have proved anything to me, it's how powerful asset protection is in accomplishing the job of deterring people from continuing to pursue a lawsuit or file it in the first place. So critical. Against what types of claims will asset protection planning protect your assets from? Well, the answer is virtually all claims if done properly. And this is really the distinction between asset protection and insurance. Asset protection is protection of your assets from anything. Insurance is protection from a particular thing that you do. So there are very different ways to go about protecting you. I believe in insurance. I have insurance. I don't want to drive my car without it. I wouldn't feel very safe. But I certainly don't consider it full net worth and protection. It's not something that, it's like protecting pockets. What asset protection does is it protects from virtually all claims, whether it's lawsuits. It limits your exposure from personal guarantees. It isolates loans. and it augments your insurance. So, there's many cases that I've seen where insurance was insufficient just because the case turned out to be a huge one. I've seen a lot of automobile cases that have turned out to be very big, and the $300,000 or even the $1 million of coverage was totally insufficient, and they started looking at personal assets. So it's really about making yourself unattractive. And again, we spend our lives making ourselves attractive. Well, here's an area where you want to be really unattractive. You don't want to be the kind of person that the plaintiff's attorneys think is attractive. What is the cost of not getting asset protection? Well, really, it's just taking unreasonable risk. And the risk is, at some point, your assets can't be protected. So remember, time is against you when it comes to waiting on something like asset protection. You can think of it as net worth insurance. You're insuring your net worth. But to do that, that insurance has to be in place before your net worth is threatened. And that is, really the people who are clients of mine that have had plans for a long time, when they call, especially in the last 4 years, as they've called through these difficult years with problems, and I look at their plan and I see the date on the plan, 2001, 2003, 1999, 1997, it's just so easy to use their plan to help them out of their current situation. And that includes bank loans. And I want to go back to one thing I said just a minute ago, and I kind of brushed over it, and I want to go back to it. Limits your exposure for personal guarantees. Personal guarantees come in different forms. You can have a personal guarantee that says, I'm guaranteeing this, but it is not giving the bank or the person that you've given the guarantee to access to your assets. It's just a personal guarantee. You can sign another kind of personal guarantee where you are specifically giving the lender direct access to your assets, either individually or as a whole. So if you are going to sign a guarantee, I recommend that you sign only a personal guarantee, not a personal guarantee that actually extends to specific assets. And if that's confusing at all, please call me. I'm sorry if that is at all confusing, but it's a very important distinction because, personal guarantees are unfortunately, or fortunately, just the way that business works. We have to give our personal guarantee when we're getting a loan. But there's a right way and there's a wrong way. All right, so it's your family, it's your money, it's your life. Act like it. Really, act like it. This is yours. And I see a lot of people today that are honestly acting as if this isn't theirs, that they're not responsible for it, that they didn't make it, and they're doing that with their investment philosophy. They don't feel comfortable, and they're afraid to talk to their financial planner. This is your money. Getting it was a job that you know what it took to get it. Keeping it should be taken just as seriously. So my recommendation is that you don't make this an area that you just kind of pass over or take lightly. I recommend that you take it very seriously. If you already have and you're here on this call because you want to take it even more seriously and you want to get support, and that's fantastic, and that's why we're doing this call. If you haven't done it, then I'm strongly recommending that you do. Okay, the time to start is now. We already talked about the sad story of being too late. I want to address one other thing here, and that's the concept of fraudulent conveyance or fraudulent transfer. Most people don't start thinking about asset protection until it's too late. So what fraudulent transfer is the concept that if you transfer an asset with an intent to delay, hinder, or defraud a creditor, that transfer can be reversed. So that is the issue about starting too late with your planning. Now, what's very misunderstood about fraudulent transfer is that it's actually not fraud. And there's a lot of confusion around that. It's not fraud. It's a remedy statute which allows the court to undo the transfer. It is not criminal and it doesn't put you in jail. It's simply a remedy. But it is important in asset protection, and if there is an Achilles heel to asset protection, that's it. It's fraudulent transfer or fraudulent conveyance. So the key to it again is doing it before you have the problem. I want to give you a tip here, and that's a word on Swiss banking. I'm bringing this up because this is really a fantastic way to protect assets on many different levels. And the Swiss private banking system is what we're talking about, not UBS and Credit Suisse. But it protects both in conjunction with your asset protection plan. It's a way to physically already move those assets. So we're moving the assets when we're talking about Swiss banking to a Swiss bank inside of your asset protection trust. That's the ultimate in asset protection. So now we have possession physically outside of the country and legal title in your asset protection plan. So you have control, but your assets are not here to be grabbed. It also does something else, and this is something I've become very aware of and very concerned with in the last 4 years, and that's the actual safety of the banks and institutions that we hold our money in. If you're a client, you know that I sent a letter out at the end of last year stating my concern around institutional risk. Institutional risk means that the bank that you hold your money in one day is not there, or is in bankruptcy and you can't get your money immediately, or you can't get all your money. Now, 5 years ago, this was all history. We would only talk about bank failures in the context of the past. You know, years ago we had bank failures, and since modern banking and modern finance and modern government has been around, we haven't had any real banking failures to speak of, and certainly nobody lost any money. But then 2008 happened, and people lost money. Bear Stearns went under, Lehman Brothers went under. Real money got lost. FDIC did not step in and give everybody back their money. And then we had just recently MF Global. This is maybe the most concerning one to me because this one happened just a few months ago. And we have real customer money that was clearly legally in a segregated account that's gone. And I know that this is true because I have people calling me and I have clients that had money there that are not going to get all their money back. They're getting a fraction of their money back. It might be 2/3, but it's less than 100%. And for me, anything less than 100% is unacceptable. I'm very concerned with the Tier 1 capital ratios of the U.S. banks, and Switzerland solves that because their private banking system there is incredibly safe. They have Tier 1 capital ratios that are 5 times what we have in the United States. There's personal liabilities of the partners and the executives of the bank for customer monies. So if your segregated account somehow disappears, the partner of the bank is literally personally responsible for that according to Swiss law. And again, the asset protection benefits are tremendous. This is something it's very difficult now for a U.S. citizen to get a Swiss bank account. For our clients, we still are able to. I honestly don't know how long that will last, but I do recommend it. I really do because it's so strong. Okay, so we're going to get some questions. What I want to do is just make sure that you're all clear that you are free to call us. If you're a client and you heard anything on this call that said, wow, I should call and check and see if this is correct, my invitation is please do. You know how to get a hold of me, Coletta@lodmel.com, or the phone number that's on the screen. You are free absolutely anytime to call me and schedule an appointment, and we can go over your planning specifically. If you're not a client yet, then what I offer you for being with us on this webinar tonight is that we'll coach you through an issue. And our clients know that we do this, and we do it all the time with them. But even if you're not a client, we'll do it, and at no cost. And that means we'll walk you through it. We'll walk you through the considerations of what you need to be thinking about. Whether you need asset protection or not, we'll help you with a particular problem that you're having. Whether it's financial stress, a foreclosure, an employee relationship, or you want to just go through the process of understanding whether you need asset protection. I invite you to call. The number is on the screen, the info@lodmel. You can reach us, and all you have to do is raise your hand and say, please drop me an email there and say, please give me a call. I'd like to discuss and state your issue. and we'll get back with you and we'll call you. And so then let's go to some questions. Now let me leave that last slide up. Okay, so I'm going to look through the questions here and see. Okay, wow, we got a lot of them. All right. Okay, is it possible to protect assets of attorneys in California? Is it possible to protect assets of fiduciaries, trustees, attorneys, in fact, in California? Well, sounds like it's from an attorney in California. The answer is yes, it is possible. It's possible to protect any of your assets. So the answer is yes. And again, for the attorneys and advisors on the call, let me tell you, you guys need asset protection, all of you. Not just your clients, but you guys do. Because you're acting in those fiduciary roles, you're acting in a capacity that does have a lot of liability. You really are equivalent in so many ways to doctors in how the amount of risk that you take on when you're dealing with your own clients. So yes, the answer is yes to that question. So if you want us to talk about that specifically, again, I recommend you shoot me an email. Okay, next question from Mark. I have my office building in my LLC. Can I put my boat, jet skis, motorhomes, and cars in the same LLC? I also have the FLP. Okay, so Mark sounds like a client of ours. The answer is probably not, Mark. We probably don't want to put the boat, jet skis, and motorhomes in the same LLC as the office building. Why is that? Well, first of all, the office building, depending on the amount of equity that it has, the office building is the big part that you want to be protecting, right? I mean, you want to make sure that that's protected. If you put a super risky thing in, like a boat, then what you're doing is you're going to create more risk for that asset that's really valuable. So the general answer is no. Probably either want to leave them out altogether and make sure they're insured well, or we probably want to just create a separate LLC for those. Okay. Next question is asset protection versus bankruptcy. We're getting this a lot. People are calling, and this is a very common question, so thanks for asking it. Asset protection versus bankruptcy. People are calling and going, well, you know what, I'm just going to declare bankruptcy. I'm not going to try to protect my assets. The answer to that is that bankruptcy is about the last place that I would ever want to be. You have just invited a bankruptcy trustee and the court to literally just walk right in to your life and go through everything. It doesn't really help you in your negotiations. It just throws everything into someone else's decision. And I strongly recommend against it if there's any way to avoid it. Occasionally, there's times when you just have to do it, but it's not a good thing. It's not the type of thing that you want to use as a primary line of defense. And if you have assets, I would much rather do an asset protection plan, even one with less than perfect timing, than to just consider bankruptcy as the option. So. Answer to that is, really only in the most dire of circumstances am I going to use bankruptcy. Okay, let me see if I have some more questions. Okay, how to create a legacy trust? How to minimize taxations after my death? That's the question. So answer to that is, a legacy trust, that means a lot of different things. But your asset protection trust is a legacy trust. So when we create a legacy trust, when we create an asset protection trust, what legacy means is something that is for your legacy. And legacy refers to your children and your grandchildren and your great-grandchildren. So if you want to create a specific type of legacy trust, often referred to as a dynasty trust, what that refers to is often a generation skipping trust, where you're using certain tax advantages to skip a generation for estate tax purposes. So the answer to your question is that it can be done. It's very common, and our asset protection plans can be used for that specific purpose. And how to do it is to have a very clear idea of what you want. You want to have clarity. Clarity is power. And so by having clarity, we can design your plan to not only protect your assets, but also protect them for your legacy, for your children and grandchildren, great-grandchildren, which is one of the big benefits of an asset protection trust, is that, at your death, the plan does not have to go away. And, as I've had children of clients call saying, my parents have passed, what do we do with this plan? My answer is keep it. It's stronger than ever before. There's no reason for you to get rid of it. It's been paid for, it's aged, it's as good as it could possibly be. Hold on to it. So you are doing that, and it's also protecting assets. If you happen to die in a circumstance which leaves a big liability, well then you've really solved your problem by leaving your estate inside of an asset protection plan that can serve as your legacy trust. So it's a great question, thank you. Okay, so here's the next one. After we have the AP structure in place and funded, there are times, such as a mortgage application or an annual loan maintenance, when we are asked by the lenders to submit an asset inventory list. Should we list underlying individual assets, various bank and brokerage accounts, rental property and businesses, as we always did before, or from asset protection standpoint, should we only list the limited partnership and the trust, the International Wealth Management Trust? Should we disclose our personal limited partnership ownership percentages and the fact that we are beneficiaries of the trust? What are the pros and cons of the different choices in terms of asset protection? Wow, great question. That was from Kevin in California. Great question, Kevin. The answer is that, really on a personal financial statement, you want to be as general and as clear as possible. But I would not list every bank and brokerage account. I would list the general assets, your interest in the partnership, and the assets that the partnership is holding is likely what the bank is going to want to see, but I would not get into the detail. There is no set rule on how a financial statement needs to look. It needs to be clear and it needs to be honest. So you do own those assets inside of your plan. But there's no requirement for you to go and detail every account and account number, etc. The general philosophy here is that you don't really want to be sharing any more information than you are really required to. So when it comes to banks and loans and so forth, share the minimum, but share it clearly and honestly when you do so. Some banks will require specific things. They'll say, you know what, I don't care about the legal structures, just list the underlying assets. If that's the case, that's fine. There's nothing wrong with that. Some banks just want to see the legal structures and they don't really care about the assets, they just want to know the value. So they just want you to estimate the values on there. If that's what they want, that's fine too. So the answer to the question, Kevin, is that it's really fairly specific. So, look at what they're asking for and do accordingly. Okay, next question is from Robert. Robert, how do I get my Schwab accounts into a Swiss bank, and can I use it to invest that money? It's a great question. The answer is yes, you can use it to invest that money. How do you get it into a Swiss bank is that just like if you were going to move from Schwab to TD Ameritrade, let's say, you would open a new account at TD Ameritrade. Once it was open, you'd call up Schwab and say, hey, wire my money over, or they have a interbank type of memo transfer that they transfer over the positions themselves into your new account. And then you can either keep or close your old account. So the answer to the question is that first you have to open the Swiss bank account. That's something that if you're a client of ours, you would do through us. You would do it in the proper entity, likely your asset protection trust. And then after that, you would simply move the Schwab money over to the Swiss account. As far as investment options, you have every option that you have here over there. Plus, you can hold your account in 22 different currencies as a base currency of the account. And it doesn't have to be one of the 22. You can hold it in all 22 of the 22. So your investment options off of the Swiss platform are actually much greater than your investment options off of the US platform, which is another reason why I like the Swiss platform. Not only is it safer, in my opinion, it's more asset protected, but it also has better investment options. What it doesn't have, and this is really something that as U.S. people we're not necessarily used to, is it doesn't have discount brokerage type services. So if you're used to paying $9 a trade or $2 a trade, I don't know what it is nowadays, but whatever it is, and logging in and doing all that online, that's not the Swiss banking platform. It's very much personal service. It's very much an investment philosophy. But if you do like to trade with a piece of your money, then what I usually recommend is that you keep the Schwab account open and you keep a piece of your money there that you like to trade with, and then you put the bulk of it in the Swiss account. This allows you the best of both worlds. You can still trade and have your online platform and your charting and whatever you do, and you can also still have your safe account with all of your money in the Swiss side. So great question, Robert. Thank you for that. Okay, this question is from Jeff. If the transfer to a Swiss bank isn't made until an event of duress occurs, but the plan has been in place for over 2 years, could this transfer be considered a fraudulent transfer? Great question, Jeff. For those of you who are not clients, and he threw out some vernacular there that's unique to our planning, which is an event of duress. I'll explain it. An event of duress is a lawsuit or some other event that causes the plan to be threatened. So that's an event of duress. So the question is, if the transfer to the Swiss bank isn't made until an event of duress occurs, but the plan has been in place for over 2 years, could the transfer be considered fraudulent? The answer is no. As long as the plan has been in place for 2 years, the transfer to the Swiss account is not a fraudulent transfer, because the conveyance is into the trust or into the partnership, depending on where it is now, at the time that you set up the plan. So this gets back to the importance of funding. You really want to make sure that you have it funded properly, because the funding is key. So as long as your money is in the limited partnership before the event of duress, and then after the event of duress we determine that it's time to trigger the plan and move that money to the Swiss account in the name of the trust, we don't have any problem at all, because it's already been funded. There's actually no conveyance made at that point. There's only a movement of the money from one institution to another, and that's completely fine. So great question, Jeff. What is the cost? This is from Tanya. What is the cost to set up an asset limited liability partnership? Okay, so I'm assuming you're talking about an asset management limited partnership. The cost to set that up, and I'll answer generically and then I'll answer for us. Generically, in the asset protection world, it runs anywhere from $5,000 to $10,000 to set up an asset management limited partnership or an equivalent type of plan. The asset protection trust, the international trust, runs anywhere from $20,000 to $50,000 and up to set up. And those trusts typically cost $3,500 to $5,500 a year to maintain. Our costs are $5,250 for the asset management limited partnership and $19,500 for the trust. So we're at the very low end of that scale, and our annual maintenance fee is $1,500, $1,495. So again, it's about a third of what even the next lowest international trust plan is out there. And that's just the way we do it. And I can explain some distinctions around how we designed it, but I can tell you that I designed it specifically to be very easy to maintain. That was my goal. I wanted it maintainable because I know that this is the key to the plan. If you don't maintain it, you don't keep it. By the time you need it, it's gone. So great question. Thank you. All right, from Karen. Do you offer investment opportunities? Okay, thanks for asking that, Karen. No, Lodmell & Lodmell does not offer investment opportunities. I personally have created an investment fund for my clients. It's not something that it's public or not talked about, and I'm not going to talk about it here because that's not the purpose of this call. It is something that I'm happy to talk with you about. I can tell you the philosophy around it is basically around safety. My goal is to in this environment, my goal is not to figure out the next best investment strategy. I leave that to the investment manager people. My goal is to protect your assets, and my mandate has always been to protect my clients from an unlikely but potentially devastating event. And that's always been lawsuits. But I can tell you the last 4 years, 3 other areas have creeped up and are competing for the top spot as the unlikely but potentially devastating event. And that's market risk. In other words, the risk of what you invest in. Institutional risk, meaning the risk of where you hold your money. That's the Citibanks and the TD and everything else out there. And currency risk. In other words, the currency that you hold your money in. I'm very concerned about these things, and my goal is to create as much protection as possible. So I looked at investing 4 years ago from an asset protection standpoint, and I said, wow, in this world where uncertainty has become the new norm, the only thing I could be really sure of is to not be in the game. I mean, that's what would make me feel the most comfortable, is to not be invested. And so I kind of started from that premise, and the answer is that I came up with, if you could take your money and basically take it off the table for the most part, let's say 80% of it, and then you could put 20% back on the table in a way that efficiently managed that money and earned you an amount that was equivalent to what you used to earn on all the money, but without taking risk on all the money, that to me would be a good asset protection investment structure. So that's what I looked for, and that's ultimately what I designed. So if anyone's interested in that specific conversation, again, I invite you to email me directly, info@lodmell.com, and I'd be happy to have that conversation with you personally. But thanks for the question, Karen. Okay, from Scott. What's the minimums to open a Swiss account? That's a great question, Scott, because there are minimums. Swiss accounts are not easy to come by. There's very few institutions that will actually open accounts for Americans. And the minimums are, really it's $1 million is the minimum. An account can be opened for $500,000 if the bank is aware that that's a starting balance and that ultimately the customer is going to be adding money. The days of the $50,000 Swiss bank accounts are over. They did exist at one point, but they were never good. They were always sold under the wrong context. The real Swiss banking is limited now, and it really is a higher threshold. So it is a great question. I wish it were lower. I wish everybody could get into it. But the bottom line is that it really is, $500,000 is really the real world minimums in the Swiss banking. So great question. Okay, a lot of questions. This is really good. Thank you all for the very thoughtful questions. Okay, John, how is the international trust kept domestic for tax purposes, and what IRS forms must be filed for compliance purposes? Great question, John. This gets to the distinction of how we design our trusts. Our trusts are designed as domestic grantor trusts, which means that they are domestic, meaning U.S., and they are grantor, meaning they're pass-through. So there is no tax forms that need to be filed as long as it's in the pre-triggered mode. They are registered in an offshore jurisdiction, and they are set up to spring to the Cook Islands in the event that we have an event of duress. And an event of duress, as we said earlier, is a lawsuit or anything that would threaten those assets. So the answer to the question, John, is that we keep it domestic by making sure that we start it domestic. And we trigger it when and only if we need to, and that an event of duress occurs, we make that trigger call and we move the jurisdiction of the trust. At that point, it becomes a foreign grantor trust. So it's still a grantor trust, it's still passed through for tax purposes, but at that point there are different IRS forms. Once it becomes a foreign grantor trust, you have to file Form 3520, 3520A. When you transfer money, you have to file the Form 90. It's called an FBAR form, 90 TD.11. And so, there are forms once it becomes, but it's still pass through. It still doesn't make it where it's a separate tax entity. And, if anybody out there has heard the rumor that, if you open up a Swiss account or any offshore account and you put your money into it, you don't have to pay taxes on that until you bring it back. That's just false, completely false. You pay taxes on all the money you earn worldwide, and that's because the United States has worldwide taxation. That's just what we do. We are worldwide taxers. And that's just the system that we live in. You can have your money in a Swiss account, and if you don't earn any dividend or interest, you don't have to pay any taxes. But if you do, you will. And the Swiss bank will give you a 1099 just like the U.S. bank will. So Swiss banking and asset protection in general is not for avoiding taxes. I can't say that clearly enough. It's really not. And if you hear that you can combine those two goals, you're probably talking to someone who is deliberately trying to mislead you or is simply very uninformed. But either way, asset protection and tax planning don't go together, especially that type of tax planning. Great question, John. Okay. Okay, so I have a question from somebody saying, hey, I don't usually feel comfortable dealing with such important issues over the phone or online. I totally understand. And the answer to that is it's all about getting comfortable. So we talk to our clients constantly, all day, and of course I visit with clients all the time. So I'm in Miami, have an office in Arizona, and any client or anybody who's interested in becoming a client is absolutely welcome to see us in person. And some do. Some just flat out and say, hey, I want to see you. I really encourage that and welcome that. We have beautiful offices in Miami Beach, and it's beautiful down here, so you can use it as an excuse to get away. For our clients that are used to dealing with us on the phone, I think what they find is it's actually easier because they get us right away. I'm back with clients within 24 hours, 48 hours. I mean, it's very fast because I'm able to be very efficient. Whereas, if I were down at the end of the street, sometimes it might take 2 weeks to find an appointment where we could come into the office. So our clients are used to getting really prompt service, and they find that being on the phone actually supports that, not the other way around. So it's a great question, though. Thank you for asking it. Okay, so next question is from Karen, and I thank you all for hanging in there. We're going now, over an hour. And I really appreciate you all hanging in there. But these are great questions, and I'm going to get through all of them if I can. So Karen, can you sell an asset to an LLC? Sure, why not? You can sell an asset to an LLC, or you can contribute an asset to an LLC. Normally, when you create an LLC and it's your LLC, and you're going to contribute an asset like a piece of property to it, you do it in the form of a contribution. And that's a tax-neutral event for the IRS. So what you're receiving as a consideration for that is you're receiving the membership interest in the LLC. So there's a specific exemption allowable for that doesn't create any negative tax consequences. But, Karen, it's totally possible for you to sell an asset to an LLC. For some reason that makes more sense to you, or perhaps you're not the only member in the LLC and you have, let's say, 3 partners, and they're interested in this asset that you have, then that asset could be sold to an LLC in which you have an interest. So absolutely is the answer. And again, if there's a specific question around that, please call us directly. Okay, so Scott, how much percentage should each LLC be owned by a trust? Okay, it's a very good question. How do you structure the LLC ownership percentages? It's a very good question. The answer is, it depends on what your goals are. But in general, we can use a single member LLC owned by the limited partnership, which in turn is owned by the trust. So that's our normal structure. The reason we like that is that the single member LLC doesn't generate an extra tax return. On the other hand, if you have a partner, let's say in an office, and it's 50-50 partner, well then you're going to have 50% interest, and that'll be owned by your limited partnership, your asset management limited partnership, and your partner will own his however he's going to own his. So the answer is that there's no set rule that it has to be a number of members. There has been some case law recently, particularly in Florida, where single member LLCs have been looked through. And again, there's specific times in which that occurs. Florida, for example, has actually changed that, and they've statutorily said, no, you're not gonna. Then that often happens. Arizona did that at one point. Where a construction or an understanding of the law was one way, and then a court ruled the other way, and then Congress of the state legislature came in and said, no, that's really what we meant, and they statutorily changed it. So the answer, Scott, is that it depends on your state, depends on what is going to be happening. So I have a question that says, is this call recorded? The answer is yes, I am recording this call. I am going to rebroadcast this, and I will give everyone on this list, everyone who attended, as well as those who signed up but couldn't attend, access to the rebroadcast. So it will absolutely be rebroadcast, and you'll have the whole thing, and you can watch it over and over again if you'd like. Thanks for the question. Okay, John, if the assets are still located in the USA, i.e. real estate, but owned by your International Asset Protection Trust, would the U.S. courts still have jurisdiction, or would you be protected? That's a fantastic question. And the answer is that yes, the U.S. courts would have jurisdiction, of course, because as we said, possession is 9/10 of the law. Real estate is here, so the courts have jurisdiction. They can do what they want. The question of would they be protected? Well, the answer is legally, yes, they would be protected. Practically, maybe not. Well, how do we deal with that? The answer is that as long as we've set up the structure properly from the get-go, meaning that the property is in the right entity, maybe an LLC owned by your partnership, which in turn is owned by the trust, if it looks like we actually are going to have to use it, meaning that we're actually going to have to defend the property, then we're likely going to be removing the equity from that property. And that's done one of two ways. We're either going to sell the property altogether. So, if the choice is sell the property or lose the property, I'm going to choose sell the property. Or we strip the equity from the property. And that used to be very easy before 2008. Now it is somewhat difficult, but definitely still possible, and certainly is doable, especially if there's a lot of equity. So the answer, John, is that we would still protect that property, and it is protectable, but you do have to have the plan set up properly from the beginning in order to have that option when the time comes. Great question. Okay, Paul, what are the advantages of a limited partnership over the proverbial Nevada Corporation plan for asset protection? I really appreciate you asking that question. The Nevada Corporation, let me just spend 1 minute on that. The Nevada Corporation rumor is that, start a Nevada Corporation and, you can protect your assets. What that really refers to is the idea that in Nevada, the corporate structures are not required to be registered, and therefore you can have bearer corporations or corporations that are owned by whoever happens to bear the shares in their hands. And it's really a tax play. And the idea was back in the days that you'd start a Nevada corporation and the corporate tax rate was only 15%, and therefore you would run your business and you'd shift income over to that Nevada Corp and you'd pay a 15% tax instead of your personal 35 or 39.6% tax that it used to be. And if you needed to shelter more than 50,000, which is when the tax rate increased, you'd start a second Nevada Corp. So that's where the whole Nevada Corp got its claim to fame. One, that doesn't work. It's a very, very bad idea. And two, from the standpoint of just a Nevada Corp for asset protection, well, you're really right back in the same boat. It's definitely within the United States. It's definitely subject to full faith and credit of other courts and jurisdictions. So, the Nevada Corp per se is not an asset protection vehicle. My general feeling is that you really shouldn't use them unless you happen to be a resident of Nevada. They're likely to get you into more trouble because they've been so abused. They're not per se illegal, but they're just so abused that I stay away from them unless there's a very specific purpose with the right kind of client. Great question. Thank you for asking that. Don, since you're in another state than California, if we work with you as my spouse is uncomfortable since you're in another state and it would be difficult to meet with you in the event something should happen to me and she is more suitable in speaking in Japanese. Yeah, I totally understand, and that's definitely a consideration. What I usually do is I recommend when you're talking about the estate planning side that you work with someone in California. And that's the piece where you're actually making the decisions on where you are going to pass your assets, who's going to be the executor, the successor trustee, and so forth. That really would make sense for you, especially in your case, to work with someone in California that she can meet and be comfortable with. When it comes to the asset protection side, though, I would still say that it makes a lot of sense to work with the best person and a specialist that you're comfortable with. What I do is I work a lot with local attorneys that are doing the estate planning side, that are interfacing directly with the family, and then I'm coming in and just doing the asset protection piece, which is really not who's going to take care of my kids piece. It's the what do I do if I get sued piece. And so that's really the key distinction there. And it's a great question, and I'm happy, absolutely thrilled to work with anybody locally that you're working with. And if you want to just call and kind of discuss how that works, then I'd be happy to talk about that. But thank you for the question. Rod, you raised your hand. You want to say something? Are you there? Oh, okay, great. Good to talk with you. How you doing? So. Yeah. Thank you. Thank you. Thank you, Rod. I really appreciate that. And I'll talk about Cedar a little bit. He mentioned employees, and so that is a huge area. We really, this webinar was not based around employees and employee lawsuits and so forth. It's really an asset protection update. But it's a huge issue. And Cedar, what he was referring to is the Center for Employment Dispute Resolution. That's a company that I co-founded with Paul Edwards. And it really is designed to support you in your practice with your employees, because we saw this as a huge lack, a huge area of people just getting it wrong, not knowing where to go. There was no real resource for the small business to get absolutely top-notch advice and service around their employees. And so we dedicated an incredible amount of effort and time to developing that expertise. And Cedar is a support structure for your practice. We do employee handbooks, associate agreements for associate doctors in your office, even hygiene agreements for hygienists, and then of course ongoing support to help you maintain your practice. So again, you can email us here, info@lodmell.com, and if you say send me the employee information or please give me information around Cedar, I will make sure you get that. Thank you, Rod, for the comments. I really appreciate that. And what you said about what asset protection has done, it really is. It really is about sleeping at night. I mean, that's the biggest benefit. When you sleep at night and you wake up and you can practice, and you can practice without being defensive, you can do your job the way you intend to do your job, the way you want to do your job, that you don't have to feel like you're literally at risk every second with every patient, with every client, with every customer, with every employee. It just makes life less stressful. My goal is to reduce the stress of my clients so that they can focus on what they want to be doing with their lives, which is, for most of them, working really hard and making the money that they need and then enjoying it. And I find that they're able to do that when they handle issues like asset protection and estate planning, get it out of the way, and then forget about it and move on. So thanks for the comments, and let me see if I can get through some more questions. Wow, there's a lot of them. You guys are fantastic, and I will just keep going. What is the annual cost? This is from Nancy. What is the annual cost to maintain the three entities, the LLC, the LLP, Asset Protection Trust, CPA, attorney, and other compliance costs? Okay, that's a great question. The legal annual cost to maintain a full plan are $14.95, and that's just the legal piece. That covers all of your minutes and maintenance. It also covers when you do it through us, I'm referring, of course, that we don't bill you by the hour. So if you call, I speak to your CPA for an hour, I talk to you a few times a year, you're not going to get individual bills from us. We designed our practice to be on the same side as our clients. That's what we want to be. We don't want them thinking, I don't want to call because I don't want to get the bill. I want the opposite going on. I want you to call because I want you to know that you have access to the right answers when you need them, not worry about the bill. As far as other costs, accounting costs and so forth, the structure is pretty straightforward. The only additional tax return you have is a federal Form 1065, which is for the partnership. And if the LLC is a single member, there's no extra tax return for that. I'm not going to opine on the cost of the 1065, but it's not unreasonable at all. It's just like any tax return. The simpler it is, of course, the less it would cost. But maintenance costs for the planning are something that we worked very hard to make sure that they stayed reasonable so that people can maintain their plans. And we have very few people that feel like they get to the point where they can't maintain them because of that. And that's critical, because there's no point if you do it and then you don't maintain it. So, but thank you for the question. Great question. Okay, so question from Doug. I hear that Swiss accounts are becoming less desirable as IRS is demanding disclosure. Okay, that's a great question, Doug. Thanks for asking that. The answer is that Swiss accounts have always been undesirable if the purpose of the Swiss account is to not disclose. So your question is saying they're becoming less desirable as the IRS is demanding more disclosure. Well, the answer is that the IRS has always wanted disclosure. Back in the day, Swiss accounts were used to hide money. The IRS didn't like it then, they don't like it now. Swiss accounts that are disclosed, however, are completely fine. So it's really back to the comments of, tax planning, certainly tax avoidance like that, should not be confused with asset protection. If your Swiss account is something that you've told the IRS about and that you pay your taxes on any money that you earn, then you will not have any problem with the IRS, the US government, or anybody else. If, on the other hand, your Swiss account is designed to hide money and evade taxes, you will have problems eventually. And I certainly wouldn't recommend that you do that, and I certainly don't let my clients do it or set up plans in that way. So it's really important. But thanks for asking that question, Doug. That was a great question. Okay, so Brett has a question. With all the changes in the banking industries in the US, including new treasury notes, can we hold many different currencies in the Swiss bank? Yes, the answer is yes. You can hold 22 different currencies in your Swiss account. And it's all the hard currencies around the world. You can also hold individual physical things in your own segregated vault or box over there if you happen to have things that you want to protect like that. So the answer is yes. That's, you can just imagine Switzerland is used to having money from all the different countries and the different denominations. So the answer is yes, it's very easy, that's what they do. Question from Dean, is an offshore trust in Belize still okay? Yes, Dean, the answer is yes, we still do it the same way today as we did it when we set up your plan. We register our trusts in Belize so that we have a clear offshore jurisdiction, that's an asset protection jurisdiction, for a registration date so that it's literally written in stone down there that this is when this occurred. You get a certificate from there. It does not make the trust a foreign trust. So it's not actually a Belize trust from the US IRS standpoint. And we also pre-wire your trust to the Cook Islands. So we set it up so that it will be in the Cook Islands. And if we trigger the trust, we're going to trigger to the Cook Islands, even your trust. So the two-tiered system of being in Belize first with a US trust that springs to the Cook Islands is how we can keep the fees down. I mean, that's the simplest way for me to explain it, because doing it any other way, basically there's no way to get around having annual maintenance fees of around $3,500 and up. And so this really provides the best of both worlds. We have all the protection that we need and we can get, and we have very minimal cost to do it. So yes, your plan is still just as good as the day. In fact, much better. One note on that, if you've had your plan for more than 10 years or anywhere near 10 years, just consider it rock solid. There is a 10-year look back in the 2005 Bankruptcy Act, which was written by the banks and the credit card companies to protect them. And they said, we're going to look back on any self-settled Spendthrift trust for 10 years. Well, if your trust is 10 years, you've even defeated bankruptcy. So your trust is just getting better and better throughout the years. So hold on to it is my advice. Okay. Another question about recording the meeting. Yes, we are, and I will send the rebroadcast. Another question from Don. Does a trust have to be recorded as well as a family limited partnership? Trusts don't have to be recorded. We do record our trust, and that is just part of what we do, because anytime you record something, you're adding legitimacy, you're adding clarity. A recorded instrument is clearly, there's no dispute that it existed, whereas a non-recorded instrument could possibly be disputed. So we do record, but there's not a legal requirement to record a trust. No. Great question. Lee has a question. Why use an Arizona limited partnership? That is a fantastic question. Why would we use an Arizona limited partnership as opposed to a California or any other state? Well, the answer is that Arizona has very, very strong laws that protect the creators of the limited partnership against creditors. These are statutory, and they provide that the exclusive remedy against a limited partnership is the charging order. whereas some other states say don't provide it as the exclusive remedy. So they leave some discretion in the hands of the judge, and we don't want discretion in the hands of the judge. We're constantly wanting and working to remove discretion from the judge. We want the judge to be totally, hands tied. Back to possession is 9/10 of the law. We want you to be in possession and in control, and the judge to be trying to get into your assets versus the other way around. They've grabbed them all, and you're trying to get them back. So Arizona is just a great state. The other reason Arizona is good is that they don't charge an annual fee, and they don't require you to do an annual registration. Even in states like Nevada, which is also a great asset protection state, they charge an annual fee of $85, which the $85 is no big deal. But what it is it's just one more thing to miss, possibly, inadvertently defeating your plan. So we like to go for creating as maintenance-free and as worry-free a plan as possible. And of course, we are in Arizona, and we are able then to serve as your statutory agent, making it easier to manage. So those are all the reasons we use Arizona. Great question. Another question from John. John says, how long can a grantor, trustee, or protector be detained for contempt of court in the U.S., and does this ever really happen? I.e., do courts order grantors, trustees, or protectors to reverse a transfer? Yeah, John, that's a great question. That's like, it's almost like an urban legend now that, if you use an asset protection trust, you're going to be thrown in jail. The reality is that there have been only a couple of cases in the history of asset protection where the grantors have been thrown in jail. And those cases were egregious, to say the least. There's certainly never been a case that I know of where a grantor or settler of a trust has been thrown in jail when he didn't really deserve it. And certainly never one of my clients has been thrown in jail. So the answer is that it's theoretically possible, but practically, if you're setting up your plan properly, you're not doing something that's completely, thumbing your nose at the court, or, in both cases I know, one, they set up the plan right before the liability, right in the middle of an arbitration, and the other was when, we had a true fraud being perpetrated and they set up a plan. As long as you're not doing those things, then your chances of being put in jail for contempt of court are in my opinion, slim to none. So, but it is a great question because I know people are concerned about it and they do ask. Okay, so, okay, another question from Don. This is regarding the California issue. Can you prepare things to work with a referral lawyer there? Yeah, we can absolutely work with referral attorneys. And again, any attorneys, advisors, CPAs, financial planners on the phone, if you have clients or you have situations or concerns, please call us. We're very much open to that. We do work with a lot of clients. And that's just part of what we consider our job is to work with you. So we're really open to that. So please don't hesitate to call us. And Rod, with asset protection, are we the only ones with access? That's a great question, Rod. Who has access to your money? Well, the answer is that you do. And for the vast majority and usually 100% of the entire life of your plan, you're the only one that has any access to the assets inside the plan. The plan is structured to make it so that the only time you would not have or be in direct control of your plan is when you've triggered your trust in an event of duress and where you having that access would actually jeopardize those assets. So the answer is that you are virtually always in control of your assets, and that's just the way it works best because, again, our goal is to make it sustainable and functional in a way that works, not to make it difficult and scary to manage. So yes, you should be in control of your assets virtually all the time. I think we're down to our last question. So that was it. I want to thank everybody. This has been great for me. I'm really appreciative of everybody who showed up. As I said, we had over 700 people sign up for this webinar. There will be a rebroadcast. It'll be out within a week. And I'll send it to everybody here so you'll get to work on it again, listen to it again, take time, invite your spouse or somebody else that you want to see it. And again, my invitation to you is if you have any questions that we can be helpful with, anything that makes sense that you just want support in walking through, or whether it's discussing asset protection specifically, financial stress in your life, a foreclosure issue, or even employees, call us. We'd be happy to help you. That's what we're here to do. And clients, please call if this has raised questions for you about your plan, or you just want to go over it and have a review. We're here for you at any time. So thank you all. I really appreciate your attention, and this concludes the Asset Protection 2012 update from Lodmell & Lodmell. My name is Douglas Lodmell, and I thank you for joining us, and we'll see you next time.